Why is common law nuisance often so surprising? Imagine living in a neighborhood where a neighbor's loud music or a factory's smell suddenly lands you in legal trouble. You might think only clear laws matter, but common law nuisance can be quite unexpected. It covers many situations where someone's use of property unreasonably interferes with others' enjoyment or the public's rights. The surprising part is how broad and flexible these rules are. Unlike strict laws, common law nuisance depends on context, reasonableness, and specific circumstances. That means what's okay in one area might be a problem in another. For example, noise that's acceptable in a busy city might be a nuisance in a quiet suburb. Courts look at how long the disturbance lasts, how severe it is, and whether it's typical for the area. This makes the rules unpredictable and can catch people off guard. There are two main types of common law nuisance: private nuisance and public nuisance. Private nuisance happens when someone's actions interfere with a neighbor's use of their property, like loud parties, bad odors, or water runoff. Public nuisance affects the community at large, like a business emitting foul smells that spread through a neighborhood or city. What's interesting is that common law nuisance doesn't require the activity to be illegal. It's about whether the interference is unreasonable, harmful, or disruptive to health, safety, or comfort. So, even activities that are technically lawful can become nuisances if they disturb others enough. Another surprising fact is that nuisance claims can be made even before the nuisance actually happens. If a person or business is likely to cause trouble, they can be held liable. Also, if a property has structural defects that cause nuisances, owners can be responsible even if they didn't directly cause the problem. This broad scope means people and companies might face legal action for activities they never expected to be problematic. In the realm of quirky laws about public decorum and behavior, common law nuisance can lead to some strange fines or lawsuits. For example, a bizarre or minor behavior might be considered a public nuisance if it unreasonably disturbs the peace or safety of the community. Because the law is so flexible and depends on context, it can be used to address all sorts of odd or eccentric disturbances that aren't covered by specific statutes. This makes common law nuisance a tool for enforcing public decorum in unexpected ways. So, if you're planning to host a loud party, run a noisy business, or even do something unusual in public, remember that common law nuisance can come into play. It's not just about breaking a law, but about whether your actions are reasonable or disruptive enough to bother others. That's why it's often so surprising, because what seems harmless to you might be seen as a nuisance in the eyes of the law. Staying aware of how these rules work can help you avoid unexpected fines or legal trouble for actions that might seem perfectly fine to you.